This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. We have some interesting stories about the diploma privilege. Some of the headlines are: Florida bar exam moves to online format in August. Texas should cancel its 2020 bar exam. Minnesota might allow law grads to bypass bar exam. Pandemic could bring student exodus from legal profession. 6-week delay in Delaware bar exam. Texas to keep July bar exam, but add a September test date. Philly bar pushes provisional attorney licensing during pandemic. And so one of the key phrases or terms that I've seen a lot over the last few days or few weeks is something called the diploma privilege, where you are able to practice law without passing the bar, basically. And there's some interesting history behind this, so I wanted to talk about this. If we go to Wikipedia, the diploma privilege is a method for lawyers to be admitted to the bar without taking the bar examination. 32 U.S. states and the District of Columbia and Wisconsin have a diploma privilege. Wisconsin has a long-running diploma privilege, and we're going to go over Wisconsin's today, so I'm actually going to skip over that a little bit. The diploma privilege then obviously becomes a little controversial. I had to sit for the bar exam. I had to spend thousands of dollars and 2 months of my life studying for the bar exam. Now, how does this work? You go to school for 3 or 4 years usually. You have up to 7 under the ABA rules, but 3 to 4 years is typical for law school. And you finish law school, you graduate in May, like May 11th, May 15th, something like that, and you're done. Your student loans become due, but you don't have authorization to practice law yet. So you then have to purchase a bar exam preparation course, because it's a hard exam. You don't generally want to assume that you're going to be able to study for it using freely available materials. There's a huge multiple choice test called the multi-state bar exam, usually 6 hours, 3 in the morning, 3 in the afternoon, of multiple choice questions, which are, if you've ever had the real hard multiple choice questions, they're basically all real hard multiple choice questions. Yes, they vary in difficulty, but they're all there on the harder end of the scale. They're trying to trick you with the multiple choice questions. You have to be able to see the distinctions and understand where those tricks are and where those wrong answers are. And then another day, usually 6 hours of essay questions. So they'll give you long answer questions, and they'll give you full essay questions where here's a whole scenario plus the fake laws. They're written like real laws, but they're simplified so you can make use of them on the bar exam without having to refer to weird exceptions that are in the actual law and stuff. And some states have a 3-day bar exam where there'll be yet another day of essay questions or other format of questions. Usually not 2 days of multiple choice. It's usually 2 days of essays or long answer and 1 day of multiple choice bar exam questions. Skipping all of that is kind of nice and kind of a privilege. A diploma privilege. So wouldn't you think that some people would be very, very upset that they had to pay thousands of dollars, spend 2 months of their life prepping for the bar exam, 2 days of their life in intense anxiety taking the bar exam, and then you don't get your results for 2 to 3 months after that, because it's an essay exam. They have to read every single one of the exams, sort of normalize the answer for the exam, normalize, what's the model answer that we're going to make here, if they haven't already, compare everybody's examinations to the model exam, probably double check those, because, what happens if there's some skewing or bias or something. So you have to normalize it again, or somewhere in there you have to normalize it. And then they turn the results out 2 or 3 months later. So you have not practiced for 5 months when you finish law school. So it's a tremendous advantage to get a 5 months head start on practicing, on paying off your student loans, on getting a job. You're 5 months ahead of people who didn't have that opportunity. So you might think that if there's a discriminatory disparity in here that prejudices one group against another, that there might be said discrimination lawsuit. And there was. So in Wisconsin, for example, Wisconsin has a diploma privilege that only applies to schools in Wisconsin. If you studied the law in Wisconsin, in a Wisconsin law school, and got a Wisconsin law school degree, you can qualify for a law license without taking the bar exam. But if you are not in Wisconsin, you do not get this privilege. Well, don't we live in some kind of federal society, federal civilization, federalized union of states? And isn't there something called a privileges and immunities clause or a equal protection clause or something like that, that should mean that you can't discriminate against people based on them living outside the state, but being otherwise qualified? So I will let a very famous writer, judge, author tell us what to think about this in the United States Court of Appeals for the 7th Circuit in the Corinne Weissmuller, and this is important, and Heather Devon case. So there's two people here, but you're going to see why this is really important. Corinne Weissmuller had to get out of the case, and Devon had to come into the case, or the case was going to get thrown out. So that's why there's two of them there. And then it was also a class action, and against John Kosobucky, who I'm assuming is like the either on the Supreme Court or somebody in charge of something in the state. And this is by Judge Richard Posner, who is a amazing writer. And this is, again, in the 7th Circuit. This is an appeals court opinion. It doesn't say for publication or not for publication, so I'm assuming it's still some kind of persuasive or binding authority. Wisconsin allows graduates of 2 law schools in the state, Marquette University and University of Wisconsin, to be admitted to practice law in Wisconsin without taking the Wisconsin bar exam. The plaintiffs and the class they represent, which has been certified, are graduates of accredited out-of-state schools who want to practice law in Wisconsin. They have sued members of the Wisconsin Board of Bar Examiners and the Supreme Court, charging a violation of the Commerce Clause of Article 1 of the Constitution and seeking injunctive relief. So they're seeking an order preventing this from happening. They can't do this. They argue that the diploma privilege discriminates against graduates of out-of-state law schools who would practice law in Wisconsin. They appeal from the district court's grant of the defendant's motion to dismiss the suit for failure to state a claim. So they lost at the lower court just right at the beginning. They don't have standing, or there's some other problem with their claim. Graduates of accredited law schools in states other than Wisconsin who would like to practice law in the state are at a disadvantage vis-a-vis, or compared to, graduates of Wisconsin's 2 other law schools, because unlike those graduates, to be admitted to the Wisconsin bar, they have to either have practiced law for 5 years in another state or have passed the Wisconsin bar exam. The amount of preparation required for taking the bar exam with a good chance of passing is significant, and for applicants who prudently enroll in a bar review course, costly. The ever-present risk of failing the bar exam and having to therefore retake it, perhaps repeatedly, imposes a further contingent cost in time, money, and reputation. Such applicants also pay a higher fee for admission to the bar, and having to take the bar exam delays their admission to the bar, though not for as long as having to practice for 5 years in another state. It comes as no surprise that more than 2/3 of the lawyers in Wisconsin never took the Wisconsin bar exam, although an unknown number were excused from having to take it because, rather than graduating from a Wisconsin law school, they had practiced for 5 years in another state, in exile, as it were, from Wisconsin, writes the judge. The defendants concede these points, but argue that as a qualification for practice in the state, the study of law in a Wisconsin school is a responsible substitute for passing the bar exam or for having practiced law for a significant period of time in another state. They also argue that plaintiffs lack standing to sue because the only relief they seek is an injunction against 3 words in the rule of the Wisconsin Supreme Court, the words "in this state." An applicant who has been awarded a professional degree in law from a law school in this state that is fully, not provisionally, approved by the American Bar Association shall satisfy the legal competence requirement by presenting to the clerk a certificate showing the following: satisfactory completion of legal studies, satisfactory completion of elective study areas, and credits and all that. The defendants argue that because all that the plaintiffs want by way of a judgment is an order expunging the 3 words, they would still be bound by Section 2. It's a pretty good point. Even if the plaintiffs win their case, they still have to take the bar exam, so what have they won? They've just made everybody else also have to take the bar exam. So it's sort of an inverse, like you're not asking for a privilege that you don't get, you're asking for somebody else to not have a privilege that you don't get. But the defendants err in assuming that the last sentence in the subsection, all semester credits so certified, etc., requires a study of Wisconsin law, or that the law schools that the plaintiffs and the members of their class have attended have less rigorous requirements than those imposed by the subsection. Indeed, so far as appears, every class member could establish that his or her law school studies conform to the requirements set forth in the rule, except that the law school was in another state. Anyway, the requirements of subsection 2 are applicable only to graduates of Wisconsin law schools, as the defendants concede, and as is plain both from the wording of the rule and from the statute, which sets forth the qualifications. But the plaintiffs cannot be right that the Constitution requires Wisconsin to extend the diploma privilege to all graduates of any accredited law school in the United States, which would be the effect of just striking the 3 words. They overlooked the fact that the unequal treatment can be eliminated without conferring any benefit on the plaintiff that challenged it. If the diploma privilege is invalidated and, in response, Wisconsin requires all applicants for membership in the Wisconsin bar either to take the Wisconsin bar exam or to have practiced for 5 years in another state, the plaintiffs will be in the same position they're in now. Leveling down is a permissible form of compliance with a command to end unequal treatment. So the judge is saying, yes, you can actually do that. You can say, I have these higher requirements, everybody else has these lower requirements, and I'm injured by them having lower requirements, so they should have higher requirements as opposed to me having lower requirements. If that makes sense? But we do not know what exactly Wisconsin would do to comply with a ruling invalidating the diploma privilege. It might require all applicants to take a continuing legal education course in Wisconsin law in lieu of a bar exam. That would give the plaintiffs most of the relief they seek. We cannot say that the probability of such a mode of compliance is so slight that the plaintiffs cannot show that they have anything to gain from winning their suit, and so cannot be permitted to maintain it. A former president of the Wisconsin Bar Association, an opponent of the diploma privilege, has been quoted as saying that he has no preconceived view as to whether Wisconsin should abolish the privilege altogether or extend it to graduates outside Wisconsin, nationwide. We said in Main Street Organization of Realtors that as long as there is some non-negligible, non-theoretical probability of harm that the plaintiff's suit, if successful, would redress, the fact that a loss or other harm on which a suit is based is probabilistic rather than certain does not defeat standing. So standing is going to be this requirement that you have to have an actual injury that is either actually happening or is an immediate injury, not something months, years in the future. Something that can be redressed by a court order. And I think there's some other requirements in there, but it has to be happening now. If it's not happening now, or if it's not affecting you in the right way, then you don't have standing to sue. You're not the right party. When is this really clear? Well, if my neighbor gets into a car accident and she's seriously injured, and I'm not a lawyer or I'm not her lawyer, can I just go to court and sue? Leonard French sues on behalf of his neighbor against this other party. No, I don't have standing. I'm not the injured party. I did not suffer the actual concrete injury, and therefore the remedy isn't going to be my remedy, et cetera, et cetera, et cetera. So that's what standing is. When it's really close, that's when it's harder to understand where standing is. And this one's kind of close. So do they have an actual injury or not? Yes, Judge Posner says that they do. So there is no jurisdictional obstacle to the appeal, and we pass to the merits. The Supreme Court has adopted what amounts to a 2-tiered approach to analyzing state economic regulation under the Commerce Clause. So you're going to love this part. If you aren't familiar with the Commerce Clause, you're going to not only learn about the Commerce Clause, but you're going to learn about the Dormant Commerce Clause. The Dormant Commerce Clause is kind of a weird inverse of the Commerce Clause. I'll let the judge explain it, and I'll fill in any blanks. When a state statute, so state is important, when a state statute directly regulates or discriminates against interstate commerce, this is critical, absolutely critical. It's very important that you understand this is states versus interstate, or when its effect is to favor in-state economic interests over out-of-state interests, so economic protectionism, kind of like, nationalism, we're better, except instead of saying we're better, we're just saying we're going to make regulations that protect our state. Famous examples of this are regulations like this one that say you can only hire a lawyer in your state. So it's fine for state law. Yeah, you wouldn't hire a New Jersey lawyer to prosecute Wisconsin state law. But What about things that aren't within the state, like copyright? Can Wisconsin regulate Leonard French's ability to consult or practice in Wisconsin, to handle copyright law in Wisconsin? Well, it can to a little bit of a degree. The court system can say there can be requirements to practice in the court system. But can somebody from Wisconsin call Leonard French, and can Leonard French answer questions about copyright law? Yes. But Wisconsin then could not regulate copyright law. Now, there's a different question. That's a preemption question. That's assigned by the Constitution. Copyright is federal. This is going to be federal because it involves interstate commerce. We have generally struck down the statute that violates interstate commerce without further inquiry. When, however, a statute has only indirect effects on interstate commerce and regulates even-handedly, we have examined whether the state's interest is legitimate and whether the burden on interstate commerce clearly exceeds the local benefits. But immediately, the court added that we have also recognized that there is no clear line separating the category of state regulation that is virtually per se invalid or automatically invalid under the Commerce Clause, and the category subject to the balancing approach, a different approach. In either situation, the critical consideration is the overall effect of the statute on both local and interstate activity. This is an acknowledgement that the two tiers sometimes cannot always be distinguished in practice, as this case illustrates. On the one hand, the diploma privilege does favor the economic interests of Wisconsin law schools, but on the other hand, it has only indirect effects on interstate commerce and regulates even-handedly. A state's right to regulate admission to the practice of law in the state is unquestioned, even though the result is to impede the interstate mobility of lawyers. But since that is a consequence, the regulation must at least be minimally reasonable. So we're going to use minimal scrutiny here for this. We emphasize minimally. The judiciary lacks the time and knowledge to be able to strike a fine balance between the burden that a particular state regulation lays on interstate commerce and the benefit of that regulation to the state's legitimate interests. We apply this principle to the regulations of bar admission. In this appeal, we find ourselves in an evidentiary vacuum created by the early termination of the case by the grant of the motion to dismiss. So here's where things are going to start to fall apart. The case never went through trial. There was never an evidentiary hearing. The plaintiff never got a chance to prove that there was a violation or that they were damaged, that they have standing. The judge dismissed the case right off the bat on the defendant's motion to dismiss. So, for suppose a supposition not only consistent with, but actually suggested, that Wisconsin law is no greater part of the curriculum of the Marquette and Madison law schools than is the curriculum of Harvard, Yale, Columbia, Virginia, Texas, Notre Dame, Chicago, Oklahoma, and Northern Illinois, which is a stone's throw from Wisconsin, as are 3 law schools in Minneapolis, that would suggest that the diploma privilege creates an arbitrary distinction between graduates of the 2 Wisconsin law schools and graduates of other accredited law schools. And it is a distinction that burdens interstate commerce. Law school applicants who intend to practice law in Wisconsin have an incentive to attend one of the Wisconsin law schools, even if, were it not for the diploma privilege, they would much prefer to attend a law school in another state. He gives an example of Hunt v. Washington State Apple Advertising Commission. North Carolina passed a law requiring apples to be graded according to a local standard. Compliance would have required the unpacking and relabeling of apples shipped from out of state. And the expense would have made Washington apples non-competitive with local apples. So it was the out-of-state apples. And the expense would have made the out-of-state apples non-competitive, more expensive than the local apples. In both that case and this, plaintiffs have a good that they want to sell in the state that makes them jump through more hoops than their local competitors in order to be allowed to sell. It is true that the out-of-state law schools are hurt along with their graduates who would like to practice in Wisconsin, and that no law schools are plaintiffs, but that cannot help defendants. The members of the plaintiff association in the Hunt case were middlemen as well as producers. The effect of the diploma privilege on the decision where to attend law school is well recognized. Would-be lawyers who intend to practice in Wisconsin would be well advised to attend one of the state's 2 law schools. That's because Wisconsin is the only state in the country that still allows graduates of his 2 law schools to be admitted to practice without having to take the bar exam. So we continue. It is enough that the aspiring lawyer's decision about where to study and therefore about where to live as a student can be influenced by the diploma privilege to bring this case within at least the outer bounds of the Commerce Clause for the movement of persons across state lines for whatever purpose is a form of interstate commerce. The defendants argue that the rule of the Wisconsin Supreme Court that we quoted requires that the curriculum of the Wisconsin schools include Wisconsin law, but that cannot be inferred from the language of the rule. And they said above, the curriculums were largely the same between in-state and all those out-of-state schools. The Wisconsin bar exam does include the multi-state professional responsibility examination, which is a national thing, and it includes the multi-state essay examination, another nationally recognized test. There's also the multi-state multiple choice. It's called the multi-state bar examination, or MBE. It's a multiple choice exam. I don't see that listed here, but they might use that as well. And if they do, those are all national tests. An alternative possibility might seem to be that the state Supreme Court, by virtue of its having created the diploma privilege and not revoked it, decided that it trusts 2 local law schools to prepare its students for the practice of law in Wisconsin and trusts no others. That cannot make any sense, if indeed the curriculum of these schools is no more weighted to Wisconsin law. And we're going to skip a little bit to the end. The judge says the case was dismissed prematurely and must go back to the district court for further proceedings. We intimate no view on the ultimate outcome and are simply remanding because the plaintiffs were denied an opportunity to try and prove their case. This was back in 2009, so we should have some news on this, right? We should have some real clear news on this, right? And here it is. Drum roll, please. They settled. They settled for $7,500. We did not get new law, but let's take a look at what the result was. In an effort not to violate copyright law, I will just look at the facts and read off the relevant facts. There was a $7,500 settlement, it looks like. They retain the diploma privilege. It remains exclusive to graduates of Wisconsin law schools. The case was dismissed twice. Weissmuller twice won appeals, but the district judge decertified the class. So it means that Weissmuller was the only one left. He eventually took the bar exam, so his case is moot. That's why they had to then bring in, was it Heather Devon, because we needed a new plaintiff. And then they settled. They can never again challenge the bar admission process. They can't assist, be part of, or support anyone else's challenge. So they took basically a minimal amount of money, probably for the amount of money that they wasted in the process. So they broke even, I guess, in a sense. Wait a second, let me back off of that, because they probably paid for those appeals too, right? Like, if these were not pro se appeals. These were probably appeals. It doesn't say here, but these are probably appeals with an attorney. So they may have spent more like $100,000 or more appealing this. So I take that back. But they got $7,500 for it. And I feel so bad because that's so little money, and they didn't win anything other than that. In September, more than 70 Wisconsin lawyers petitioned the state Supreme Court to abolish the bar exam for any ABA accredited law school, or to make the local grads take it too. The court has taken no action. And let me see if I can find anything recently, because that's from 10 years ago, obviously. Wisconsin Bar says something. So here's the 2010 article. So it tricked me. It said back here, it said June 17th, 2020, but it's not. It's from March 25th, 2010. So this is the state retains its diploma privilege and someone will have to challenge it. So you could probably successfully challenge that. Be prepared for a multi-year process. Be prepared for appeals, and don't ruin your own case by becoming admitted to Wisconsin by taking the bar exam in the middle of your case. Because now that they've taken and passed the bar exam, they no longer have any requirement to take it. So it's moot. There's no longer any claim here. So. Interesting case, but yeah, that's the diploma privilege, and that's the effect of the diploma privilege. So is it now different that we're in the middle of the coronavirus situation, and should we be totally okay with the diploma privilege, at least for this year, because you don't want to have these people in violation of social distancing and other mitigation efforts by having them all, while nervous and distracted, pile into a room of hundreds or thousands of people and take an exam. You could figure out how to do it, but it would take some extra effort to do it safely. So maybe they just do it this way instead. Let me know what you think. That's our show, everybody. I'm Leonard French, your favorite copyright attorney. Lawful Masses is a community-supported legal education and legal news channel. Thank you very much for your support on patreon.com/ljfrench and sponsors.com/law, and YouTube memberships and Floatplane memberships and Twitch subscriptions. Special thanks in the month of July to BU1 Simmons. And thank you to the July $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory, Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to the July $5 plus supporters. Everybody's scrolling on the LED panel and will be on the crawls in the videos that drop. I love you all. Have a good week. I'll see you soon.